Okay, so my name is Phillip Landolt. I'm a lawyer in Geneva, Switzerland, practicing from the law firm Landolt & Koch in international arbitration. And I am your host, your moderator of this webinar, which is on teams and file management. It is an important topic, crucial to the success of your practice as counsel in international arbitrations, but I bet it's the very first treatment of it because everybody overlooks it. Why is that? Well, it's a bit technical and it's not very glamorous. People don't tend to think about it, but it's mission critical. If you can organize your filing of your case, your files, that is, and your teams, how you organize your teams, you have a really important advantage. And one of the interesting things is that a lot of established law firms really have a great deal of legacy knowledge about this. One of the advantages arbitration law firms have, arbitration teams at good law firms have, is that they have processes to deal with file management and team management. So an important topic, a topic we're looking forward to exploring today. Let me please introduce our speakers. First speaker is Natalia, who is a practitioner in international arbitration at the law firm of Hogan Lovells, based in the Dusseldorf office. Natalia Gulyaeva is a lawyer qualified in England and Wales, Germany, and Russia. So that's quite impressive because those are three very different legal systems. And Natalia is specialized in technical IP and regulatory media and technology. So we welcome Natalia to today. Second, we have Gaele Yotsapay-Tete, who is practicing from TGS Baltic in Vilnius, and she is specialized in energy arbitration. And has been involved in a number of very important commercial and investment arbitrations in that sector. Our third speaker is Vasiliki Kuompli, who is an Athens-based arbitration practitioner, a senior associate at Watson, Farley & Williams, and Vaso is also specialized in energy arbitration. These are very, generally speaking, they engender very big arbitrations, and therefore we have some real expertise on our team here in regard to and team management. You can read more about our speakers on the chat. I posted their biographies, well, a brief biography. I've summarized their biographies. Please let me know over the Q&A if you cannot see these bios over the chat, and I'll do what I can to repost. Right. So before I begin, I want to tell you a bit about the structure of what we're going to be doing today. We're going to hear first from Natalia, then Gaele, and then from Vaso. Each will make a presentation on their assigned part of the material. And then our other speakers, and perhaps myself, will comment on what has been said. We welcome questions from you at any time. Please post them on the Q&A, and I will present them to our speakers to answer. And so we do welcome your questions. So I propose that we now start in with Natalia's presentation, which is going to be matters relating to organizing the file. Natalia.
And thank you, Philip. And I'm delighted to be discussing today a crucial, yet, as Philip said correctly, often overlooked part of effective counsel practice in arbitration, organizing the file. As any experienced practitioner will tell you, the efficiency and effectiveness of our advocacy in arbitration can often hinge on how well we are organized and how well we manage, how well we access our files. So let's dive into some of the best practices in this area. The first important issue is confidentiality. Not a secret that in arbitration, confidentiality is vital. As Professor Liu and Professor Kroll have emphasized in their many works, confidentiality is one of the cornerstones in arbitration. And this principle applies not only to hearings and proceedings, but extends on how we manage our case files. Each piece of documentation, whether electronic or physical, must be safeguarded in compliance with both our clients' needs and the legal obligations we adhere to in different jurisdictions. Obligations of confidentiality extend not only to prohibiting third parties from attending the arbitral hearings, but also to a party's disclosure to third parties of hearings transcripts, for example, as well as written pleadings and submissions in the arbitration, evidence adduced in the arbitration, materials produced during disclosure, and arbitral awards. And to ensure confidentiality, it's advisable to establish protocols that cover access restrictions, secure digital storage solutions, and routine audits of security measures. Implementing permissions-based access within digital filing systems is a good practice to limit exposure, ensuring that sensitive information remains restricted on a need-to-know basis. And international law firms know well how important it is to have all these tools available in their information and documents management systems, where the documents may have different level of sensitivity and may have a different status, kind of classified, highly confidential, sensitive, etc., depending on the file, depending on the matter. And it also extends to grant of access. You can manage access to particular file or particular documents by a very narrow team of people involved in a particular matter. And you may make sure that even if someone who does not belong to the team tries to access one of the files having a particular status, the team would get an automatic notification that someone has attempted to open a document which has been secured and access to which has been granted to the team. In principle, it's enhanced of our IT and information security teams, and in our firm, we very much rely on our people in the area because it's really extremely helpful. I can give an anecdotal example where trainee attending the course in arbitration before in the ICC Advanced Arbitration Academy has got as a homework a task to prepare just as a document, a red fern schedule. And if you're a trainee, you do not necessarily know what a red fern schedule is. And this person tried to find on the system a precedent. And of course, there are precedents available as precedents, but there are also clients' documents, which some of them which you can see, but you cannot access, and some of them which where you try and you even cannot see the name of the file. And so this person tried to access the document where in the name a reference schedule has been mentioned. And after that, the team working on the file has got all those notifications that this confidential file has been, there was an attempt to achieve from such and such office by such and such person. And this person has got all the emails from the partners involved, asking what's wrong, why do you want to read this document. Therefore, based on this example, I would say that the IT and information security are a key for safeguarding confidentiality. Nowadays, this is the matter of fact. The second element, electronic or physical. Should files be electronic, physical, or both? As some of you, I'm sure, are aware, the debate between electronic and physical filings is ongoing. Recently, the FCIArb delegation attended the Ancestral Working Group 2 discussions in WIG in Vienna, where the focus was on arbitral awards, whether the system should not switch to electronic awards only. But the question is broader, because electronic awards or electronic files, all that is very, very much connected. And those who work for international law firms or domestic law firms know how much focus and how much pressure we have from the firm's management for switching for paperless, for switching to electronic filing and keeping all the documents in electronic format on our files. And indeed, in some instances, wet ink documents and wet ink signatures are prescribed and needed because the law requires this. But in many cases, this is not what we are facing, and electronic filing is much more efficient. Starting with electronic and determining paper requirements, I think it's the first element in this. While electronic files have clear advantages like easier searching and retrieval, often arbitration still, as I said, requires paper for certain filings, correspondence, and official submissions. In these cases, start by managing the core of the file electronically and determine if any documents must be printed and stored physically to comply with arbitration rules or tribunal preferences. As Gary Bourne discusses in his treatise on international arbitration, aligning with the tribunal's formal preferences can avoid procedural disputes and unnecessary delays. Therefore, I think tribunal's preferences are also important. As to electronic filing, assuming electronic files form the core of our file management, we need a systematic, organized structure to make them accessible and searchable. Let's discuss some effective methods for this. First, creating optical character recognition, OCR versions of every document can significantly improve your efficiency. This approach allows you to search across entire files for keywords, which becomes indispensable when you are dealing with thousands of documents in a large arbitration. Second, organizing by sections and categories. You may have a section containing only a client document, all documents from the client, including contracts, including correspondence and any relevant documentary evidence. These files can be clearly labeled and dated. And as Jan Paulsen notes, thorough documentation management can make or break a case, especially in matters involving complex evidence. I faced searchability issue, how critical the searchability issue is myself on several occasions, where the team was in the process and were pleading, and the question arrived, which required a very, very detailed information from the case files. And of course, we were very fortunate that we were organized in the way that we could search electronically through the whole, it was a big case, through all the materials, and within literally minutes, find exactly what the tribunal wanted to hear from us. And I have to say that in that particular case of which I'm thinking now, that was critical for success in the arbitration. Secondly, correspondence. I recommend separating correspondence files into two categories. Those with the tribunal and those without. And by indexing each correspondence file with a date and party identifier, such as, for example, you put a date, then you say claimant or respondent, then you say the name of arbitration institution, and you name the document, for example, extension. And you'll have a chronological reference at your fingertips. The system aids in tracing the evolution of case discussions and spotting how the discussion developed. Simultaneously, you can see the gaps and you can solve and cover the gaps when you identify such. Third, administrative documents. Administrative records relating to a client relationship should be stored here. Powers of attorney, fee agreements, non-disclosure agreements, etc. Maintaining this separately helps ensuring that sensitive client agreements and terms remain secure, but at the same time are easily available when you need to check something. Separately, I would add a section for submissions, creating distinct folders for submissions from the claimants and respondents, so that pleadings, memorials, and any other formal filings are easy to locate. Separately, I would file procedural orders, terms of reference, schedules of submissions, ensuring clarity on procedural milestones, so that part would be purely focused on procedure. It's good to have drafts put separately because, as we know, in our profession, drafts are essential, especially in cases involving multiple counsels and multiple revisions. Label drafts by date and keep them separate to track the evolution of submissions or arguments is really, really important. Usually, the firm's information system, document management systems, allow tracking such evolution, but it only works well when the whole team working on the case has an impeccable discipline in saving documents in an agreed way. As soon as someone does not comply, it's a mess, and you do not want your case to be messy in any part. In addition to those sections, categories which I've mentioned, I would add a couple. I would add maybe subfiles within categories, subfiles within procedure, within submissions, within correspondence that can help you to keep specific subtopics or key exchanges accessible. And this is particularly useful for the cases involving complex procedural history or simply extensive correspondence. Then the database files. If you maintain a separate data room or database, this is very, very useful because many team members can access the documents simultaneously. And two more, it's one very important, even if we do not say it openly every time, but billing, because maintaining a clear section for billing information and miscellaneous documents. This helps to track time and cost carefully. And of course, documents managing the arbitrator's fees and expenses must be organized separately as well, because arbitration with tripartite tribunals involves compensation and expense reimbursements for three different professionals whose normal billing rates and practices may be significantly different. And there is a potential for confusion and inconsistency in the way such matters are handled. And later on, when it comes to the costs of arbitration, there might be mistakes if something is overlooked. In conclusion, organizing the arbitration file might be tedious routine, but it's a foundational to successful arbitration practice. Following a structured, categorized approach not only streamlines your workflow, but also demonstrates professionalism to peers, clients, colleagues, and tribunals. And by maintaining confidentiality, leveraging digital systems, and organizing meticulously, we set ourselves up for a seamless and effective counsel practice. I would like to finalize my presentation by citing Albert Jan van den Berg, who said, "A well-organized file is a testament to the counsel's preparedness and respect for the arbitral process." And I'm sure that further speakers will give much more to support this statement by Mr. van den Berg. Thank you very much.
Thanks, Natalia. Very useful material in what you've said. I was wondering if our presenters have anything they'd like to add on these topics, Giela and Veso. Is there anything you'd like to add? Okay. Well, I have a number of questions. I would start with this. One of the things I'm always thinking about when I'm organizing a file electronically is the degree to which I should be giving real time access to clients. It's interesting, you know, they like to be able to follow the development of the submissions, to know that they're happening. But you know, if you're anything like me, you write and rewrite and rewrite and rewrite, and the first version is not something you really want to be sharing with the outside world, let alone clients. And so what do you think? Is there an approach, Natalia and Gale and Veso, about this in general? Does it depend on the client?
Oh, it's a very good hint. I think I agree with you, Philip, that it very much depends on the clients, because I think the councils, the general counsel, associate counsel, general counsel, etc., very much like to control, but do not necessarily always have sufficient time to control. Therefore, I think you should really find a balance where, depending on your client, on the client's expectations, you simultaneously give access to the files, but you do not overdo, because there might be also some disappointment if, as you said, the first draft is not perfect yet and you're already sharing it. I think it's not necessarily helps the relationship, and especially to put into such database, for example, the document which hasn't been yet reviewed by partner. That might be really a bad element, bad episode for the attorney-client relationship. So, having said that, I know the clients who would want to follow every single step and would want to see even the first drafts, but it's about, I think, then comes to the question to be covered by my distinguished peers today. It's managing the team. If you have such a client, then you have a very, very experienced counsel or partner who handles the first draft.
Yeah. Yeah, those are important considerations. Gale, Veso?
Yeah, I was just going to add, it's also a question of managing deadlines, since that's my topic. When considering this at our law firm, we were discussing also how the work progresses and the questions from the client: why haven't you worked on this file today? Or, why hasn't the draft progressed? So it's also a question on how work appears for the client.
Yeah, absolutely. Okay. In making this determination access for clients to work in progress and files in general, are you considering also the let's say the billing aspects, the justification of billing aspects? Is there a sort of consideration more generally about justifying the billing in how you keep files? Because I think, if people don't know about law in action, law in reality, they often feel that it doesn't take much time. The lawyer has all the answers in her head, and it's a matter of speaking them. So when you're keeping files and giving access to clients, are you aware of, justifying billing?
I think there are two elements, right? The first element, if you have file properly organized, you actually save your time, because you do not waste your time in searching for documents. You just know where it is, and you go into the document, and if it's properly labeled, you can find within seconds the right version. It's not something like a crazy exercise looking through the MS Outlook for the version which has been sent to the client. You have the labeled version sent to the client on such and such date at such and such time. And this is, in my experience, this is absolutely helpful, and it contributes to efficiency. The question is, all this work which is done on labeling, on saving on the system, whether it's it might be billable or not. I think there are many clients who would agree that it contributes to efficiency, but at the same time, they would have in their billing guidelines a reference saying that clerical work is not billable. Do not even try to send us an invoice. And here, yes, we have to use support. It might be filing assistant, it might be a paralegal, but it's a person who does not have a billable target and whose KPI is simply to make sure that there are no issues within the year, that there is no episode where we have to deal with improper filing, we cannot locate something, etc. And so that's the target, and the person is compensated based on the results for this period. So I think those are my observations, but I'm sure the colleagues have something to add.
Yeah, well, I'm of the view that you've got to be extremely careful about what you give access to, and also in terms of justifying billing, I think what really matters is how you describe it. I think at the end of the day, it's very difficult for clients to understand what happens within the law firm, and giving them access, for example, to files is probably not going to advance one's position more. Another issue would be in a lot of arbitrations, you're constantly worrying about criminal investigations. You get a very politically sensitive arbitration, and you're thinking that despite client confidentiality privilege, there's going to be an investigation into your files. Do you, in those circumstances, have a policy for how you keep the files? Do you keep separate files, for example? Do you remove metadata? Things like that?
I think this is a risk which is present in every jurisdiction. There are jurisdictions where the risks are higher and where the risk is lower. But I think it's critical to make sure that the regulations on privilege would be applicable to your files. And this is, again, about the structure of the team, whether all the attorneys who work on the file have the proper status and the documents automatically are privileged, whether all the correspondence on the file has been marked as privileged in line with the local regulations, because in some jurisdictions you need to do much higher level of labeling to make sure that it's privileged. But yes, this risk does exist.
Yeah. People always think that the way documents are presented to the tribunal really affects how the tribunal views their case. And it's probably right, certainly in extreme cases where documents are so disorganized and messy, the tribunal stops thinking or stops following, stops making an effort. It also is probably right that if one is careful about the presentation and the details, it raises confidence about, the reliability of the contents. To what degree is file keeping, an essential component of that final product, which arbitration practitioners consider very, very important?
I just think that every seasoned lawyer is disappointed to get a document containing typos, errors, and this is a natural part. I think we are all somehow affected by our profession. And we are naturally disappointed if we see something messy or not done in the way how we would usually do that. I think it's very difficult to, because every lawyer is different, to satisfy the needs of every person, because one has a higher level of discipline and or just is more organized, another is less organized. They are brilliant lawyers who are less organized, but they win the cases, etc. But in how you present, I think the structure is very important. I think the ease to go through the documents for the tribunal is critical, because if it's, as you described, Phillip, if it's messy, if it's hard to follow, I think your chances from the beginning are not going into a right direction. So what do you think, Vaso?
Yeah, I was actually gonna add also, it's first probably not the tribunal that's going to process the file. It's going to be co-counsel, sorry, not co-counsel, opposite counsel, right? And it becomes a question of cost, right? If the opposing counsel has to go over the file to decrypt it, and I actually had a case where it was very disorganized, exhibits were missing, references were missing, and so on. And we had requested certain exhibits to be updated. And we requested that time to be added to the legal costs at the end of the case, obviously. So it's also a question of cost to the client, because the team was very disorganized in their filing.
Yeah.
But it may be probably used for delaying purposes by someone, right? If you give some messy documents, maybe your opposite counsel would need more time. Maybe you try to delay things in this way. It's not something what as FCIArb we would advertise, but it's also exists, I think.
I'm pretty sure that's a valid tactic that can be applied if needed. I'm fairly sure in that particular case, it was just overwhelmed team with too much exhibits.
Yeah. So one of the like most obvious ways that good file management shows itself is at the hearing. So, you know, counsel is always vying to make the better impression. And I think one of the most impressive things is when a team can drop a document, for example, or, you know, a team has documents that are really well presented. For example, photocopies that don't have all the black around them and things like that. That's very impressive. And you know, people who can produce the references, things like that, you know, like if you're discussing the case law or whatever, people can produce the references. So, you know, I think lawyers in front of the tribunal they're under pressure to do various things. But I think it's probably right that good file management really helps in that task, where, you know, you've got to think about a lot of the various things. If you've got a nice system with confidence in being able to produce a document, a clean document, a reliable document, I think it's one of the most effective elements of advocacy. And I'm sure we all have examples of this occurring. It's just it's very impressive for the tribunal. And at the end of the day, you know, I think you know, you always hear in the deliberations, we've lost confidence in counsel. You know, they haven't got that right. They gave us this citation. It's actually not right. So yeah, I think, you know, at least indirectly, good file management does have very important effects on results. What do you think?
I definitely think that if you produce one time wrong reference, it's already suspicious. If you do it for a second time, I think you maybe lost your case, right? I would say that importance of junior team members for training and skills and quick search is a key, because I have to say that my junior colleagues, they demonstrate extreme skills in search. It's within literally seconds they can find exactly what we need. And to have someone with you during the pleadings, because you cannot plead and search separately, it's obvious for everyone. And to have someone who can go through the electronic files very, very quickly, it's really an immense help. And the case to which I was referring within my presentation, that was a technology case. And basically I was asked to give an example from the file why the argument, and that it was a very, very technical file. Basically, it was about chemical formula. And we needed to support why the opponent was wrong on a particular matter. And while we had hundreds and hundreds and hundreds of legal arguments, that was an argument where we needed to provide something like a very technical. And so it was, I do not exaggerate, it was literally 2 minutes. My colleague needed to find a very good example, and we were able to refer to a particular page of the submission and say that there it is. The question was not the usual question, was I would say unexpected, but the search done and the quick answer provided helped us to win the case. Therefore, I think it's true to say, do not underestimate skills of your junior colleagues.
Yeah, they're crucial. I agree. Yeah, absolutely. And it's probably right that not just getting the right answer, but getting it in a very transparent way in the tribunal does matter. You want to look like you're being straightforward and not hiding something. And a good filing system will really ameliorate that. Thanks, Natalia. And so there are some questions from our participants. SM Yusuf asks, is it important to differentiate between original and copy documents in the filing? But once you've got them electronically, they're all copies, of course. But is there such a thing as an original electronic copy? I suppose there is. Yeah, I mean, that's probably a good point.
Yes, I suppose, unless if it is digitally signed something or something like that, and this digital signature is, let's say, approved in the particular jurisdiction. So it depends on many considerations whether we have a let's say original document in the electronic file.
Yeah, would you therefore distinguish in your filing between originals and copies?
Well, that would depend why you would have to do so. If there is a reason to distinguish between electronically signed and just photocopied documents, then this should be done, and all considerations already mentioned by you, Natalia and Galia, concerning who is going to do that and how come to discussion again.
And to this one interesting just remark from what we have learned during the Ancestral Working Group 2 discussion is that, and it's applicable here. For example, you want to file certain documents, and how would you distinguish between digitally signed award carrying scanned signatures or scanned copies of awards carrying that signatures? They may look absolutely identical. So in such cases, I think it's pretty important to label them, because you will not be able, without technical means, to distinguish them. It's important then to label and to know where you have what.
Yeah. Thanks, Sam. Athena Stafila asks about security breaches and confidential data. In fact, Athena's interested in this. Is it the responsibility of the particular file management personnel, or is it the responsibility of the law firm itself? Can that actually be determined or at least influenced by contractual language vis-a-vis the client? Can you actually provide that if there's a data breach, it's the one particular individual who's responsible? Is that worth doing? What would you think about that?
I think that while the data security legislation has developed over last several years, it's still underdeveloped. And therefore, as much as you can do to protect yourself through the corporate binding rules or through the contractual arrangements with your clients, the better and the safer you are. Because in various jurisdictions, the definition of data breach will not be identical. And if we are speaking about international arbitration, there might be various views on the issue from the claimant's country of origin or respondent's country of origin, etc. Therefore, I think contractual regulation is very important.
Yeah. Okay. Yeah. So we're talking about third party data file managers. Yeah. Veso, sorry.
Sorry, I would add that also cybersecurity liability insurance gets more and more in discussion lately due to these reasons, not only in dispute resolution field, but in general, because law firms tend to use to get digitalized to a large extent, and then such dangers are existing and have to be addressed in terms of the relationship with the clients.
Yeah. Okay. Well, one thing I would add is I think it's important to choose a reputable data file management provider, any third party provider, because very often under contractual systems, as you know, the liability is in the choice of the provider, and not how their product actually performs. That would often be their liability. Yeah, it's an excellent question. I mean, many things can go wrong. What about where there's not a theft or breach of confidential data, but there's actually a loss of data? The law firm is using, let's say, some software, and something goes wrong with it, and crucial data to the arbitration is lost. Is that the law firm's responsibility, or is it the software providers vis-a-vis the client? Those are important issues. Yeah, I think it's probably right, Athena, that one would want to make provision in the contractual relationship with the client. That said, there's often situations where you cannot immunize yourself from liability towards the client because of this power relationship. And also in terms of the optics, I don't know, I knew this situation where there was this client retainer agreement, which was 40 pages full of protections for the law firm. And I think that makes a very bad impression. So one shouldn't provide, protection for everything. Is there anything further one would like to add on this particular topic?
Phillip, I would say that a cybersecurity breach in a law firm, in any case, not only arbitration, is a very, very big damage to its reputation. Leaving aside if it has the legal liability or it has transferred it to the IT management or to the software provider. So these things have to be addressed also by taking into account the law firm client relationship, which is the relationship of trust and confidence. So this is something new, as Natalia very well said. This area is over-regulated, but not many solutions have come out of this overregulation. So it remains to be seen how law firms would be protected, not only legally from a legal point of view, but from a reputational point of view.
Yeah, absolutely. And in our area of law, dispute resolution is, of course, exposed to cybersecurity risks. You know, there are many people who want to know what the lawyer is thinking and you know, what's behind the case. And so it's probably going to be very hard to argue that precautions at a very elevated level were not necessary. It's probably the opposite. The law firm is going to really need to be very, very careful about cybersecurity, and there could be very serious liability or questions about liability in view of the lack of clarity on the law in this area. But that brings us to the question of backups in filing. You know, what do you think about backups on the cloud? Physical backups, where in the law firm, in your servers? Do you think can one express general advice on these matters?
I think it depends on the laws applicable to the country of incorporation. What is allowed? That is allowed for your client files, and then you elaborate on that in the engagement agreements with the clients, and they either accept that or not. But I think we have to be realistic, and everyone knows that most of clients, they use iCloud solutions for their documents too. And it's becoming more and more popular every year. If you do a cybersecurity check of a company, you will see that cloud solutions are basically dominating as compared to others. Therefore, I think it's unavoidable.
Yeah. Should paper copies be kept of the really crucial documents?
Yes.
Yeah. Okay. All right. I think we can move on to our next set of topics. And Gaily was going to take the lead here. Gaily?
Yes, thank you. So I will talk about the managing of the deadlines and some other practical aspects of the filings. So managing deadlines is something that irks the team the most if done improperly, obviously, and not to mention the obvious legal aspects of a missed deadline. So we have some flexibility in agreeing on the deadlines in arbitration, which is nice compared to the court system in most cases. But it's still a very touchy subject for a lot of people. So where deadlines are concerned in arbitration, I'm going to talk on one hand, the bigger picture, so planning the entire schedule, and then sort of managing the particular filing deadline. So between the two, obviously, there are some principles that overlap. And one of the core one, which I cannot stress enough, when planning for any deadline, you will need more time than you think. It's a rule that any time management assistant, time management training session is going to give you is you will need more time. So if you're just starting to plan deadlines, if you're just starting to manage projects, double your time estimate easily. If you're well experienced, I would still argue for at least 20% time reserve on whatever deadline you have. So life happens, and something unexpected will happen. And if you have a very long schedule, you have cases where the hearing is scheduled 2-3 years in advance. things will happen. So starting from the overall calendar, when you're just at the onset of the case, you have some flexibility. Obviously, you're constrained probably by the rules applicable to that particular arbitration. For example, Lithuania has a very ambitious target of 6 months for the entire case to be decided. Obviously, it works for some very simple disputes, but not for any larger dispute. Obviously, it's extendable, so you have flexibility. The core aspect here is to assess the scope of the case. And it's obviously hard to do at the beginning. Sometimes there can be other potential issues that will come up during the case, right? You need to consider the need for experts. Any technical, financial, quantum experts will obviously extend the case, and you will need more time for any filings. It's also worth to consider other projects, overlapping deadlines to the extent possible, right? You can have parallel arbitrations, which is a very nice specific case where we actually had 2 very large parallel arbitrations, which were scheduled over a course of several years and specifically coordinated between the councils to have, filing. One team is filing on one arbitration, the other team is filing on the other, and then you switch because it was a very massive case and you couldn't do it any other way. Obviously, there are some synergies between parallel arbitrations. So another example we had is where we specifically scheduled the hearings of parallel arbitrations in the same month, just weeks apart, in order to have the synergies on the preparation, on the team already knowing all the facts, all the legal aspects and so on, and just updating for the parallel case. Planning a reserve. Again, cannot stress this enough. For the overall calendar, I think the best reserve is between the last procedural action that you have and the hearing. So, or preparation for the hearing, let's put it like that. And again, if you have a sufficient reserve there, you can push some of the deadlines in the filing, whatever happened, and you will not face the postponement of the hearing, which probably is the worst case scenario, in which will add a lot more than having that additional, whether a week, 2 weeks, so depending on how big the case is, a month or something between that last procedural action and the hearing. Where the filing itself is concerned. So you have a particular submission and you have, I don't know, it probably depends on the case. You have from a month, several months. I think the longest deadline I've seen and personally had was half a year. So in those cases, I think, so what I personally do and what we try to do at our law firm is sort of 3 steps in the planning of the filing. So the first one is done whenever you receive the document from the opposing counsel. And you have a general plan with the responsibilities of the team, who will do what, who will do it by when, and how it's going to be incorporated, when the expert input is going to come in, and so on. So on this part of the planning, I think one important aspect to consider is bottlenecks. So if you are a manager or if you have a manager who is going to have to review a lot of the material, it is very important to plan that drafts or parts of drafts are going to come in on a rolling basis. Again, it's an interesting sort of trade-off, let's call it like that, between having, in a very large case, between having one person review it all and have it a harmonized, very nice document, and the bottleneck that creates, and the time constraint. You know, if you have 2, 3, 4 drafters and one person needs to review, it's going to be a huge constraint on the schedule. Expert work also puts in a layer of complexity. So if you have work that is dependent on expert work, input is needed. Obviously, you can proceed to some extent in parallel, but you need to take into account extra time needed there. The last point is witnesses. If you have witnesses that need to provide statements, those need to be signed, those need, you know, exhibit numbers need to be put in. Check with the witness whether they're going to be available for the filing. It's, again, an anecdotal example where so we had a witness who left for vacation without informing anyone, and they did not. They said, "Oh, I just forgot the key card with the electronic signature," and he cannot sign. So it's a nightmare situation where, you know, someone needed to go and physically take his electronic signature to him in his cabin in the woods for him to sign. So check with the witnesses. You know, ahead of, so when at the beginning of the process, check with the witnesses. Do they have availability towards the end for all the formalities that need to be done? Now, closer to the deadline, closer to the filing deadline, and again, the details are going to be a bit dependent on how mapped your case is. But what I really like is having a backwards calendar. So I am going to share an example that we had. I don't know if you can see the screen. So we have a backwards calendar with the paper filing, which is the very last action, and the electronic filing as our sort of target deadlines. We have a reserve before the filing. In this case, because it was a large case, we had 2 days of the reserve. And that was, by the way, used in full for the filing purposes in the actual scenario. So you can see here that we planned for about a week, almost 2 weeks in this case, of the last 2 weeks of the filing. We had 2 experts. We had technical expert, economic expert. We had witnesses. We had over 600 factual and legal exhibits, and we had a submission of 600 pages. So it was, I think, if I recall correctly, about 12 lawyers plus support staff worked on this. So it was extensive, and that's why we had quite a detailed planning in this particular case. And again, the plan has to take into account who needs to finalize what by then. Technical experts need to finish first. We had a cutoff date for the exhibits, internal cutoff date for the exhibits, just because we needed time to prepare the exhibit list, and it was I think it took 4 to 5 days to prepare an exhibit list in this case. And, you know, then you have drafting in parallel, so completing the sections that are dependent on the experts. So the YYY mentions represents the technical experts. And then you have financial experts who work on the basis of the technical experts. And it also, again, coming back to my initial sort of thread, it takes more time. Everything takes more time than you plan, and inserting the exhibit numbers took an enormous amount of time. Cross-referencing the document took an enormous amount of time. Consolidating the document takes time, and you need to plan for all those things. And as you can see here, This was in 2018, so quite a while ago. And we didn't have that many technical solutions that are available today, which could have helped with a lot of this work and which I would highly recommend using today. So some of those solutions are ability to draft on the same document. In 2018, we actually tried the solutions that were available in order to make this easier, and it did not work, unfortunately. A few years ago, we installed a technical solution which allows several people to draft on the same document at the same time. And it was by far the best solution that I could imagine. A technical solution. It was extremely helpful and extremely useful in terms of facilitating the filing. So one thing is you can see what the others are doing, how the team is progressing. You can make comments and edits in real time. On more than one occasion, I can see a junior team member drafting, and I will go, no, not like this. You need to do it differently, and this saves an enormous amount of time. There's no consolidation, obviously, and you have uniform formatting styles, which everyone is using. Whenever someone inserts a footnote, it's in the exact format that it needs to be. So I realized that I skipped and jumped to the technical solutions, but I skipped the last stage of the planning. So I've showed you the overall plan of the filing. So that was, as I said, about 2 weeks of the filing. Again, if you have a very detailed case, a large case, what we do is also have the day off plans. So at the end of the day, the case manager would allocate the tasks for the next day for someone. So who needs to do what over the course of that day to complete the work. I think that's only needed for very complex filings, but it's also a good practice to make sure that those last days count, and you don't have someone sitting on their hands and doing nothing and just waiting for instructions. We usually do it by email by this stage, and you will get an email with, this person does this person does this, and so on. So coming back to the technical solutions now. We've discussed, even here today, and there's a lot of different opinions between what technical solutions could be used, should be used, how much it should be automated, how much it should be done manually. I have seen people who will, side check by hand, and because it seems more in control. My personal opinion is whatever can be automated should be automated, and I say that with two disclaimers. One is you should have a very good knowledge of what your software can do and what it cannot do and what errors it can make. So I am for automation because it eliminates human error when it works properly. But again, I cannot emphasize enough, you have to know the limitations. So one example is we have used a filing system which apparently would not upload files if the name of the file was too long. And so obviously that was caught very early in the process, but it's just the principle itself, that the fact that you have to know this. You have to know that this particular software will not upload if the file name is too long. And it works with every, it works with any solution that you are using. AI is obviously, you cannot have a conference now without mentioning AI. So I'm taking this. It can be a very helpful tool. And we have AI that works in our system or together with our system. But again, it can do certain things like make summaries. One very helpful thing that it can do is find formatting inconsistencies, which is not a widely known fact. And it's very handy, you can look up at the document, say, find formatting inconsistencies, and it will give you a list. But it cannot do substantive work. Obviously, it cannot insert things that will go into the file. So again, knowing the limitations, and I'm not going to advertise particular solutions, particular products, but the three most useful things that a software can provide, in my opinion, is the ability to work on the same document by several people. Automatic references, so references, cross-referencing to paragraphs above, below, automatically referencing to sections, etc., which update as you progress with the file, and uniform formatting of your template. So having a good template is really important. Now, the filing itself, how you transfer the documents to the other side, to the arbitrators, to whoever needs to receive it. So we have talked already a lot about confidentiality and the security, the need for security. So I will not reiterate that point. I will not focus on that. But I think if you have the freedom of choice, my only advice would be to use the software that you know and that you can safely transfer the files to someone else, obviously with all the considerations for security. And also software that is easily accessible for the other side. So it should be user-friendly to download, so or just having good instructions to download. If you do not have a choice, and in certain cases you are required to use the filing system that the arbitration institution is providing, obviously it's you're stuck with it, for better or for worse. But also have someone very well trained with it to handle that last filing, double check. And again, coming back to the all the scams, the phishing, and the corporate security, I think it's common courtesy, if not absolute necessity at this current stage, is when transferring the documents, email and inform the other side. You will receive an email with the link. It's okay to click it, and it's basic security or basic step for the person to receive those files. Now, the last point is storing of the files after the filing, and on that front, I know, again, there are different approaches. So our firm, for example, stores all the files for extended periods in order to provide the client with the know-how and services on the basis of their previous filings or their previous requests and services that have been provided. And this came in handy on a number of occasions, including where clients have change of personnel, the loss of documents. They would come to us and say, come to a law firm and say, we don't have those files anymore. Can you give to us the correspondence with someone from 2009, and someone will pull up those files and have them. Obviously, storage comes at a cost, and it's a trade-off between the services being provided and the value of that extra mile versus the cost that you have for the file sharing. I think I'll stop here. I don't know if there are any questions.
There are, Gela. Thank you very much for your presentation and all the information in it. Ansa Mahmoud asks, for some jurisdictions such as Pakistan, where there is a statutory time limit to conclude arbitrations within 4 months, how do we effectively foresee and plan a practical schedule? And most importantly, are there any steps we can take to prioritize ensuring that the deadlines we propose in the arbitration are preserved? 4 months.
Yes, it's a very ambitious. I think so. My colleague will later on speak about resource management, and I think when you have a very short deadline, it's always a trade-off between the time that you have and the resources that you need. So the less time you have, the more resources you will need to complete a very complex case, and working with a lot of people again comes at its own challenge, and I don't know, probably my colleague will comment on that, but I don't think there are many other options. You can automate as much as possible, as I said. You can do eliminate consolidation, eliminate referencing, but you're gonna have to have more people in the end.
Yeah, for sure. One thing one can say as well is that if the deadline for getting the arbitration finished is so short, that makes the time limits, the individual time limits for submissions or whatever, the date of the hearing, really firm. So there can be no excuse. Often in arbitration, as everybody knows, a deadline is, well, in French they say a délai d'ordre. It's like it's just to keep things moving, and it's not going to be something ultimately fatal for your ability to respond. But when you get a very short time period for the arbitration, one thing you do notice is every constituent element in the time schedule gets incredibly firm, because if you want to move something, the other party is going to be prejudiced. And that makes the the deadline management absolutely fundamental. I mean, you cannot miss anything, or you'll be precluded. So I did want to raise that. Any other comments on this issue? I mean, 4 months is a really short period. Practically speaking, you're going to need to deal with evidence, and in the procedural orders, you're going to have to limit all the evidence, in particular, especially expert evidence. That takes a long time to deal with. They're going to have to be specific. They're going to have to be contractual stipulations limiting the evidence. That's the first thing one would see. If there's nothing further on this topic, Daniel Medani asks, what AI, this is a really interesting question, what AI software do you use to identify formatting inconsistencies? I didn't even know about that. That's the thing about AI. I mean, honestly, it can do everything. And it can do this. What AI software do you use to identify formatting inconsistencies? Well, I just want to say as a preface, while our presenters think about the answer, it is so crucial to have consistency in one's approach to formatting. In the United States, for example, you have these citation standards.
Blue Book.
Yeah, the Blue Book, absolutely crucial. Yeah, and it's not mere formalism. I mean, it really does facilitate the adjudicator's task, opposing counsel's task, your own task, if you have consistency in referencing. But so since it's so important, is there any AI approach one can adopt to ensure that there is consistency in formatting?
So what I mentioned, we use Copilot, and I think it works because it's integrated with our system. So it's part of the overall software that we use. I have not tested others, whether other software and other AI can do the same and whether they can review formatting inconsistencies. Obviously, it has to work on the document. So it has to have ability to see the document itself, not, online Copilot or something like that.
Okay. Is consistency in formatting an absolute good, or are there occasions where one might not want to have it? I'm thinking in particular witness statements. Sometimes the witness statement is just so much like submissions. It's formatted identically. It's formatted in the most florid, beautiful, flawless English that, it tends to suggest, doesn't it, that it's more the product of counsel than of the witness herself. That might be an occasion where you want to have some sort of deviation from a standard formatting. Can you think of anything else?
I think in relation to wording of the witness statement as well, you can tell where the witness statement was drafted by a lawyer. So it's obviously a question. Personally, I'm a stickler for formatting, and consistency between the documents is it just makes it easier to read the document, I think.
Yeah. Does the firm's personality find expression in the way formatting choices are made?
It's difficult to say, huh? It's, I don't know. I've never picked a draft and thought, this is aggressive or something like that. Although it's always nice to pick up a draft from another law firm and go like, oh, they copied our formatting.
Yeah, it often happens. I'm in a case where counsel makes asides in smaller font, so in paragraphs. So the counsel's writing the stuff that is kind of important for the case. Then there's all sorts of asides, and this never happens. Perish the thought. I think
also, you actually reminded me about all the aspects of limited submission pages. Those obviously have a formatting question. So I had one emergency arbitration where a submission was limited to a page. And you obviously receive, and both parties did that in that case. You had zero margins essentially. It was zero margins, zero spacing between lines, and But in those cases, when you have a limited page number on a post-hearing brief or on any other submission, one of two things will usually happen in my experience. Either you have a Times New Roman, some kind of font size and margins set, or an agreement between the parties that it's the same as you have filed before. So no tweaking the margins, no tweaking the fonts.
Yeah, that's there's always a way people try to escape page number limits. Anything further to add on this matter?
Simply maybe one comment is that I agree that there are many off-shelf software solutions which can be used. However, in terms of automation, my preference is to use two tools simultaneously, just for the case if there is failure on a side of one software or one database, then you have like a backup database which does still indicate you the deadline or a particular important event which may not be overlooked. While I completely agree with Gailey that you cannot predict everything, this still helps. And in our firm, we had several years ago to establish even a separate entity focused on software development. And this company consists only of software developers who write software for us, and we use it. So this is also a possibility for every business, given the challenges we face.
Okay. Syed Bilal Hussein asks whether blockchain has any relevance for filing and time management. Can anybody imagine or think of some way that blockchain could assist? For security, for example?
I guess it's a question of storage of your copies, right? So I don't know to a great detail about the confidentiality issues on the blockchain, because it has the copies recorded on all the servers, all the providers of that blockchain. So, you know, that aside, on the security side, obviously, you could have a question. It would be very secure to have a copy on a blockchain, as the same copy is recorded in every provider. I don't know the technical name, but I would be quite hesitant to use that, because anything that goes outside the firm would be extremely hazardous in terms of confidentiality.
Okay, all right. If there's nothing further to add, we'll thanks Giela for your comments and for all the reflection that is behind them. We'll move on to the second part of our discussions today. I noticed it's 11:26, so we're going to be focused as ever. Vaso will speak to us about teams management. Vaso, please. Oh, you're on mute, Vaso.
Okay, now am I audible?
Yes, absolutely, very clear.
Very much, Philip. Good morning to all. I'm very, very glad to be here and discuss with you today on these very important and quite practical topics. So turning to the topic of the teams management. Well, in international commercial arbitration, the topics reduction of time and cost and the term efficient case management are regularly in discussion. So conceptually speaking, the goal of the parties should be to resolve disputes early in the process, efficiently and cost effectively. So favored in international disputes, arbitration process may possess an array of formats confirming this well-known flexibility it has. So from a practical perspective, arbitral proceedings are largely dependent on the exercise of party autonomy. However, in order that arbitration remains an effective method of dispute resolution, it should be well managed also by the parties' counsel. And whereas the focus of discussion regularly lies on the management skills and practice of the arbitral tribunal, it is worth also address the issue from the point of view of the counsel handling the arbitration. Therefore, once it is ensured that there is a case worth pursuing, it is of utmost importance that a dedicated team be built both in-house and externally of the company involved in the dispute. So when choosing external specialized counsel, the company will mostly apply a uniform process to requesting bids, which will be essentially important to their comparative analysis. So it is advisable that the directions requested by the RFPs of the company be strictly followed by the candidate counsel. The counsel may also propose alternative fee arrangements, including the breakdown of fees by stages of the arbitration, which may allow companies to optimize their budgets. But moreover, a bonus may be proposed as a cost incentive aligned with the business's goal. For example, if the goal is to settle early, the law firm can propose a regressive incentive depending on the stage at which the arbitration is settled. But in any case, adequate resources play a key role. And in terms of the people composing the counsel team, various considerations should be taken into account, such as specific expertise, management skills, applicable law or language knowledge, technical abilities, as well as seniority of the staff. And at the same time, extraordinary circumstances should be foreseen and dealt with, such as, let's say, the replacement of team members in case of sickness or in case they leave the firm. To move on in terms of time, the council team must set aside sufficient time to swiftly proceed with the arbitration, while in parallel, we all know very well, the team members may also have other professional engagements running at the same time. And in terms of money, the composition and the work of the team should comply with the budget available, which will affect the number and the seniority of the team members involved, as well as the time frame of the completion of the tasks and the means that may be applied. Galia mentioned very well before that if the budget is low, then you have to be slower, to work slower. If you have to finish the arbitration very early, then you have to spend more money. So all these aspects and parameters are interrelated. What I would also add is that the higher the team cohesion, the higher the chances to the team to deliver a good performance. So we come to the core aspect, which is proper planning and coordination, and this makes leadership and structure of the team elements of paramount importance. And one manifestation of such leadership is the proper allocation of works and tasks, such as the regular client reporting, the dealings with an arbitration institution in case of an institutional arbitration, the conduct of legal research, drafting of documents, facts section, legal sections, witness statements, as we mentioned, is also a task of the council, maybe to draft or to monitor at least. The communication preparation of witnesses to go to the hearing, as well as the organization of documents and the search for experts. Here, seniority, particular experience and expertise are to be taken into account in the allocation of the tasks. Equally important is the ability to be flexible and to adapt to the needs of the process while the arbitration is underway, and being able to dismiss members who may not be eventually necessary or change their roles, as well as to increase or decrease the budget if this is possible in the particular case. But based on the needs of the particular case and the financial resources available, council should consider and use third parties such as co-counsels, search agencies for experts and private investigators, interpreters, or other court reporters. So what is more important is that the council should establish a regular line of communication with all those involved, so that no one is left out of the loop and all persons involved know when and how they expect updates on a matter as this matter develops. Last, external counsel should send clear invoices, clear fees to avoid confusion. In billing statements, it should provide more description and the results yielded under the billable hours. So we know that when approving a bill, the internal counsel, we need to understand and justify the expense, and very vague and opaque statements would not help to this direction. But apart from the external counsel, who is a specialized arbitration counsel, let's see now a little bit the involvement of the in-house counsel. The most important parties and biggest stakeholders in an arbitration are the companies involved, generally represented by their in-house counsel. So widely used arbitration rules seem to acknowledge this as they differentiate parties from their representatives. So in the capacity of in-house counsel, no one is in a better position to exercise party autonomy. It is through the in-house counsel's participation during all the steps of the arbitration, that a tailor-made process can be put in place to achieve better cost efficiency. So this position was reinforced by a study conducted by the ICC, the International Chamber of Commerce, a few years ago, according to which the administrative fees generally amount to 2% of the overall costs of the arbitration, arbitrators' fees 16%, and the general legal technical representation of the parties account for the remaining 82%. So it's very important for the company, for the party, to be able to monitoring such costs and have, let's say, have a say in this respect. Thus, the role of an in-house counsel may play can be important during the various steps of an arbitration, I would say from the drafting of an arbitration clause to the determination of the issues in dispute, the production of evidence, the availing of settlement opportunities, as well as finally the overall receipt of the award by the company. So in this context, one or several people internally who are subject matter experts in arbitration should be also designated by the company. This will serve as a resource within the company, centralizing the information and gathering feedback. But what would be the relationship between external and internal counsel? So in order to be effective, in order to work well, external counsel should have access to all information, and the role of in-house counsel is to obtain such information from the business to create that access. External counsel should be mindful that the in-house counsel is in the driving seat as they oversee the disputes and make strategic decisions that suit the company's goals. And simply put, in-house counsel manages the external counsel, and they report eventually the results to the board of directors so that they are also held accountable for their work. Communication between those two sides, between these two teams, is a key then, and it must be dynamic and straightforward, and in practice, depending on its client, it may entail regular meetings or status reports to check in on the progress of specific submissions. So knowing about each other's works, procedures, and ensuring that whenever there is a need for clarification coming from either side, there is a communication channel in place that is easy to use. Last, I would like to address some cultural issues. So from a cultural point of view, the need to promote diversity and sustainable development goals within the council and arbitrator selection process is being more and more emphasized in the last years. And it is becoming essential for the stakeholders involved to be conscious of social issues like gender and racial equality and LGBTQ and disability inclusive. So Council should be aware of the social issues and social climate worldwide and ensure that the composition of staffing in a representative company is a representative of the community in the particular case, taking into account multiple factors such as the location of the law firm, the composition of the in-house counsel team, as well as the composition of the tribunal. Because cultural diversity can improve the quality of the outcome of the arbitration, and it also can offer equality and openness, richness of perspectives, and therefore quality of the advocacy. In most cases also it makes a good impression on the arbitral tribunal. But however, equally there is the risk cultural diversity to be a source of misunderstanding. So lack of cultural proximity between the decision makers and the parties might lead to cultural incommensurability. So seeking diversity for its own sake is a legitimate objective, but I think that it is more important and compelling if it is sought for the sake of improving the outcome of the arbitration and improving the rendering of justice. So cultural biases, consciously or unconsciously, are present among individuals from different backgrounds, ethnic, national, or racial, and they can influence how parties and arbitrators assess each other's credibility during the process. This may lead to misunderstandings, negative judgments and prejudgments about the participants, wrong assumptions, and this may result in mutual mistrust, which does not foster a nice place to start to seek a solution to the problem we have. So I will leave it here and say what the writer Phyllis Rose said, that there is no neutrality, there is only greater or lesser awareness of one's bias. And in the world of dispute resolution, procedural remedies may be limited in case of unconscious bias, but however, the existence of unconscious bias gets more and more attention, and ideally, if an arbitrator is personally biased with respect to certain groups, this arbitrator should disqualify himself or herself from the proceedings. But again, the selection of the arbitrator never stops to play the most crucial role. And having said that, I will pass the floor back to Philip, and thank you for your attention.
Thanks, Vas. So any comments, Natalia and Gaele, about what Vasso said, her topics?
I think an important issue of diversity has been elegantly touched by Vasso, and I think it's true that we cannot avoid bias. They exist in each of us. We can do our best to somehow minimize the outcome of this. However, we have to always keep in mind, if we have in a tribunal a person who might be somehow biased, we have to think about that when planning for the team who will be presenting the case.
Yeah, okay. All right, well, is there anything further to comment on at this stage? I can ask some questions, otherwise I'll move on to some questions. So one thing that interests me is the degree to which members of the team know about the case. So the case tends to be vast and you can't know everything. So if you accept that, maybe you don't, if you don't accept that, and you think rather that all members of the team, even the most junior, need to know everything, do say. But let's just proceed for the moment upon this premise that it's not possible and not efficient, not economical for everybody to know everything about the case. Who needs to know the most about it? Is there someone who needs to know everything? And if so, is it, who's that person? A lot of people would say it's the senior partner on the case, but maybe that partner is the relationship partner. And he or she is, mainly making sure the client is well disposed towards the law firm. Or maybe it's the senior associate, because the partner, even the matter partner, has got 14 matters going. Who do you think needs to know the most? Do they need to know everything? Like, do you need, is your senior associate who's got principal responsibility for the case going to have to know everything? I mean, every detail, what everybody's doing. What do you think?
Well, ideally, everybody should know everything, but this is not possible most of the times due to time considerations, budget consideration, and expertise consideration too. So you cannot expect anybody to know everything. Sure, there should be one or a couple of senior staff of the team knowing everything, all aspects of the dispute, its progress, and what each member of the team does. If this person will be the senior partner or an associate, I think it does not matter, as long as there is a good coordination among them, and the people, the persons, the lawyers that have undertaken this role can do it effectively.
I think that CRP, client relationship partner, is very important. His role or her role is very important because clearly, if it's a big client of the firm, CRP would not know everything. However, I think in the majority of cases, CRP would expect to hear from all the lawyers in the firm, at least if something went wrong. This is something what you need to know because you need to manage the risks for the client and make also proper communication. Plus, the second very important, if there are very big important developments, you also as a CRP, you would know, you would communicate to the client as well, simply to plan ahead, because that might mean more work. And again, here we are coming to the time management, what has been covered today. There is never enough time. And also there may be additional business team expectations for you in addition to legal team expectations.
Thanks, Natalia. So one of the ways... Yes,
if I may add just on this
please.
topic, I was also accepting the limitations that everyone is not going to know everything. I always advocate for the team knowing as much as possible, just because in my experience, it helps with the quality of the work. So even if you have very junior team members, if they hear the context, the reason why this is happening, what is the goal, what is the strategy overall, it improves the quality of the work that you receive. So to the extent possible, keeping the team updated is a good strategy.
Yeah, the more people know, the better, definitely. Do you have someone who's responsible for briefing people? Is that a good idea to have someone with that particular responsibility, just briefing people, keeping people up to speed? Finding out what they know, changing their instructions for what they should know. The case has moved in this direction. You now need to start knowing this part of the case. Start reading about that. Is it useful to have one person responsible for determining what others are doing and know about the case?
Certainly, Philip, because this is a way to keep track with each step of the case, and everybody has the minimum necessary information that they need to do their work, but at the same time, somebody knows what each of the team members does, and when something new arises, such person, along with the senior partner or associate, can allocate new tasks accordingly.
Yeah, I totally agree. Yeah. Do you take into account personalities when people are forming teams? That some people really work well together. Is that a big factor? Even kind of like for team spirit and stuff?
This is about the cohesion of the team eventually, and of course, personality, attitude, and team's bias in general, and play an important role in the way they will perform as a team eventually. But this is the role and the task of the leaders of the team to deal with such differences, and which are always expected. It's not something unexpected to meet people in a team with such differences.
Yeah.
In the approach of working, in the mentality.
If I may
add
on this, there's nothing more efficient than going to your teammate and saying, "Let's do this as always," and you know that the person is going to do exactly as you want it. Prepare, whether it's preparing the exhibits, you send it for, let's do the translation of this document as always, and you will have the exact formatting. So that's one comment I wanted to make. Another one is on the personalities. It's very interesting to have certain people assigned to certain tasks based on their personalities, and it may be very efficient. Some people will be extremely diligent and detail-oriented, and that's the person who's gonna review and compile and do all of our research tasks. There are people who are extremely good at cross-examining someone because of their personality or persuasiveness, or in certain cases especially where cross-examination concerned, you have a situation where an aggressive approach would be inappropriate and you would alienate the tribunal, right? So you need to consider the personality again in the tasks that are being allocated.
Yeah.
And this is also a matter of experience, and because we often see junior lawyers, junior associates joining a team and then get accustomed to the way, such team works.
Yeah. To what extent do you take into account people's career aspirations and career development in forming teams and assigning tasks? For example, someone's never cross-examined. Do you give that person an opportunity to cross-examine, even though, person's inexperienced? What if someone... Yep.
Shadowing is preferable in the first place. So less experienced colleagues should shadow more experience in the beginning. And after a while, we see them being great in the task.
Yeah, I think so. It's a good way to reform, improve your relationships with the tribunal as well, when you're seen to be bringing on younger people, especially at the hearing. A good sign is when the tribunal retire or tells everybody, okay, go off and have a break, and then keeps the young person who's just cross-examined back for pointers. I think it's a really good opportunity to enhance one's relationship with the tribunal. Do you take into account the fact that someone you think that they're about to leave the firm in staffing case? You get that sense, that someone's unhappy or they may have an opportunity elsewhere. Is that a consideration in staffing for cases?
They often underperform from the moment they have decided to leave until they actually leave. So you have to deal with this too. Yeah,
absolutely. Do you take into account someone's desire to work with a particular partner in order to get known for promotion purposes? Has anybody found themselves doing that? Well, you don't have to say.
Sometimes it's unavoidable, right? Because if you want your colleague to progress, you need supporters for the business case, for partnership, or for a counsel position. Therefore, it's good to have just some of your colleagues working on the other partners' files. However, obviously, pragmatically, that means that you have less of this person during this time. This is sometimes sad, but if you want to support the career of someone else, you do that.
Yeah, absolutely. We have 8 minutes left, and we have some questions which are not exactly on our topic, but since we have such an experienced panel, I propose we nonetheless answer them. Mohammed Hasib Mohidin can ask, if the corporation is an alter ego of a state, what are the consequences of an intervention of a political bias in a matter of proceedings? What do you think about that? So corporation is an alter ego of a state. Okay, well, yeah, Vasu, did you want to answer that?
Just a few thoughts. Okay, this is a source maybe of influence and a source of, let's say, superiority in the room and in the process. So I would say that if the party itself cannot handle it, then it's up also to the tribunal to try to bring this equilibrium, the balance that is necessary.
Yeah, absolutely. I might add that where you get a party that is the state or an alter ego of the state, I think with a high degree of regularity, one finds that the arbitrator they nominate is almost always going to decide in their favor. So this is a very cynical thing to say, but often I think that they just feel, unpatriotic if they don't understand the point of view of the state that appointed them. And I've seen that over and over and over. And in fact, I don't blame them. I had this case where the state appointed a judge, an actual judge, a sitting judge. And so I thought that was peculiar because I thought that might be a conflict of interest, but it turns out it wasn't. I can't remember the thinking. Sure enough, extremely distinguished Supreme Court justice, he did decide in favor of the state, but I thought he did it in a very dignified way. He made the arguments that were available to make. So yeah, I mean, I think the answer to a large extent is, one needs to be accepting of certain realities, and that's one of them. The realities of political bias. Does anybody want to add an answer to Mohammed's question? Okay, then we can move on to our last question. Athena Stafila asks, is it easy or very difficult for counsel to ask for disqualification or replacement of an arbitrator because of bias? How is this allegation to be proved? So not really about teams and file management, Athena, but nonetheless, an absolutely crucial question. Getting an arbitrator removed for bias. I notice we have 5 minutes maximum, and I wonder if anybody wanted to give some insights into this matter. Well, it's very difficult to get an arbitrator.
Exactly. If it is an unconscious bias, which is not realized from the very beginning of the process, and we start to realize, even the same person, even the arbitrator starts to realize it progressively, then this has to be addressed internally and externally by the parties too at a later stage, if it results in an unfair treatment of a party.
I totally agree. Yeah. It's not only difficult, in my opinion, it's difficult. Sometimes you get very obvious facts where you can have the arbitrator removed, but there's all sorts of protections against challenges for bias. For example, in Swiss law, anything that exists and you knew about, you didn't raise, it's unavailable to you. But one piece of advice is, if you're going to challenge the arbitrator for bias, there's zero strategic interest in it, because if you lose, that arbitrator is going to be decided against you. And as much as they try, they're always going to be a bit suspicious of you. So the basic proposition is this: if you're challenging an arbitrator for bias, make sure you have a very, very strong case and make sure you win. Yeah, it's like running a revolution. You're a revolutionary. You don't want to fail in your revolution. I guess that's a very extreme way of looking at it, but it's a crazy thing. I'm very, very sparing about challenging for bias. And another thing to say is never, ever challenge for any procedural decision. The ICC will never, maybe not, virtually never, for example, remove an arbitrator for admitting documents at the last minute before the hearing. It's just not going to happen. And the Swiss Supreme Court won't either if you're in Switzerland. So yeah, I think it's very difficult to have an arbitrator removed for bias. There's all sorts of ways where you can reject that application, and there's great peril in challenging. So you have to dance with whomever you came with in international arbitration. Does anybody want to add anything further?
Can say that I cannot agree more with your comment on this question, and maybe that could be a subject for a new webinar by FCIArb European branch.
Yeah, it's a terrific topic. Absolutely. Bias, it's the Achilles heel of arbitration vis-a-vis courts, because courts, judges are always sort of sitting in the sort of smoky room all by themselves, listening to Bach, but the arbitrators are out there, hitting the streets and knocking on doors and stuff, and drumming up business, both as arbitrators and as counsel. Yeah. So there you are. Well, I think we've covered a great deal of material. I'm very grateful to our presenters for your preparations, for your reflections, for the clarity of your thoughts. I'm very happy that we've grappled with these matters, because they're not often dealt with, but they are crucial. And certainly this is the first of our series of practical skills development in international arbitration. I really think this unglamorous topic is really the starting point, because we build the foundations of good arbitration practice based on how we keep our files and how we form our teams. Thanks also to our presenters. I see we're out of time. I invite you to join us for our next installment in a week's time. And it's going to be on the comparative arbitration topics theme. See you then. Thank you. Bye to all.
Thank you.
Bye-bye.